I want to tell you something about the word confused. People use it kindly, usually, as a courtesy, as a softer word than the one they actually mean, which is diminished, which is less than, which is no longer to be trusted with the decisions of your own life. My name is Miriam Osai. I am 67 years old. I am the daughter of a Ghanaian schoolteacher and an American nurse, and I grew up in a house where both languages were spoken at the dinner table, and where confusion was not tolerated because my father believed, with the conviction of a man who had watched students fail not from lack of intelligence, but from lack of precision, that imprecision was the enemy of everything worth doing. I am not confused. I worked as a certified court interpreter for 30 years in the Riverside County court system, and in those 30 years I interpreted in Spanish, Haitian Creole, and enough legal Portuguese that 3 immigration judges requested me by name. I interpreted in family court, in criminal proceedings, in dependency hearings, in probate matters. I sat beside defendants who did not speak the language of the country deciding their fates, and I made certain that they understood every word said about them, and that every word they said was rendered with the precision the moment required. I retired in October. In November, my sons filed a guardianship petition. I want to tell you how I took that petition apart. I want to tell you about the errors I found in the first reading, the ones I sat on for 3 months while the attorney who filed it grew confident enough to make more. I want to tell you about the judge who looked up from the bench when I walked in and recognized me before my attorney had said my name. I want to tell you about the evaluation designed to confirm that I was no longer capable of managing my own affairs, and what happened when the evaluator realized who she was evaluating. But first, I need to tell you what they were actually after, and what it cost me to understand that the men who filed that petition were not strangers. They were my sons, and the distance between those 2 facts is where this story actually lies. I have 2 sons. David is 42. Michael is 39. They are good men in the ways that are easy to be good, generous at holidays, present at the important occasions, attentive in the ways that other people see. I love them without qualification. I want to say that first because everything that follows must be understood against that fact. I love them. I also know exactly what they did and why they did it, and I will not pretend otherwise, because pretending would be a kind of confusion I have no interest in. David is an engineer. He is precise, methodical, and deeply risk-averse in the way of people who have spent their careers understanding what happens when systems fail. His wife, Renata, is a real estate attorney. She is the kind of woman who notices everything and says very little, which I have always found more interesting than the opposite, even when what she is noticing is my house and calculating what it might be worth. Michael is a contractor. He builds things the way his grandfather used to build things, with his hands, with care, with the particular pride of a man who knows the difference between something done right and something done that looks right. His wife, Carla, is warm and direct, and I have always trusted her more than I trusted the situation, which turned out to be the accurate assessment. What I did not know in October, when I retired and began enjoying the quiet of a life no longer structured by courthouse schedules, was that a developer named Hargrove Properties had been in contact with David for 7 months about the land my house sits on. I did not know because David had not told me. I did not know because the conversations had been conducted through Renata, who handled the correspondence, and because what they were waiting for, what the whole quiet enterprise was waiting for, was a mechanism to manage me. Manage is the word David used later in a document I was not supposed to see. I want to be clear about that word. He did not write remove. He did not write take. He wrote manage, as though I were a problem in an engineering system that needed to be routed around rather than addressed. The land my house sits on was purchased by my husband Charles in 1987. Charles died in 2018 and left it to me outright with no conditions and no encumbrances. It is a 3/4-acre lot in a neighborhood that has been discovered, slowly and then suddenly, by the kind of development money that sees residential land and calculates square footage and density and return on investment, and does not think about the lemon tree in the backyard, or the fact that a woman has lived in that house for 34 years and has no intention of leaving. Hargrove Properties had offered David, through Renata, a facilitation fee of $80,000 if the family could deliver clear title to the property within 18 months. Not a purchase price, that would be negotiated separately with me or with whoever was managing my affairs. A facilitation fee for arranging the thing. I found this out later. I want to be honest about the order of discovery because the order matters. When the petition arrived, I did not know about the developer. I did not know about the $80,000. I did not know about the emails between Renata and Hargrove Properties Acquisitions Director that would eventually become the most important documents in the case. What I knew, the morning the petition arrived, was that my sons believed I was no longer capable of managing my own life. And I sat at my kitchen table with the documents in front of me, and I felt, for the first time in 30 years of professional composure, something that took me a long time to name. Not anger. Anger is clean and direct, and I know how to work with anger. What I felt was grief. The specific grief of a woman who has spent her life making sure people were understood, who has sat beside the frightened and the lost and the accused, and given them language when language was the only thing standing between them and a system that would otherwise roll over them entirely, and who now sat in her own kitchen, reading a petition that said she was no longer qualified to speak for herself. I sat with that grief for exactly one morning. Then I made coffee, I put on my reading glasses, and I read the petition again. Carefully, the way I read legal documents, the way my father taught me to read anything that mattered, which was slowly and twice and with a pencil in your hand. And by the second reading, I had found 3 things. I did not tell anyone about them yet. I got up, washed my coffee cup, and called my friend Adiz, who had worked as a paralegal for 22 years and who had the particular gift of knowing, when I called, whether I needed to talk or whether I needed to think out loud. She listened to me read the petition aloud, and when I finished, she said only, "Who filed this?" I told her it was an attorney named Bertram Foss. She was quiet for a moment. "He does elder law," she said, "not litigation, mostly estate planning and powers of attorney. This is not his territory." "I know," I said. "They hired someone who doesn't know how to do this properly," she said. "I know," I said. "So you found the errors?" "3 of them," I said. She was quiet again, longer this time. Then she said, "Miriam, do you know what you're going to do?" I told her I was going to let the errors stand. Another silence. "How long?" she asked. "As long as it takes for him to build on them," I said. There was a pause that I recognized as the pause of a woman who is deciding whether to argue with a position she understands completely. "All right," Adiz said, "but you call me every week." I said I would. "I want to tell you about the errors now, because they are the foundation of everything that comes after, and because understanding them requires understanding something about how guardianship petitions work, which I am going to explain not because I think you don't know, but because for 30 years I sat beside people in courtrooms and watched them not understand the processes being applied to them. And I promised myself I would never be one of those people, and I will not be one now by assuming that the process is obvious. A guardianship petition in California is a formal legal action in which a petitioner asks a probate court to appoint a guardian to make decisions on behalf of an adult who allegedly lacks the capacity to make those decisions themselves. It is a serious proceeding. It requires specific documentation, specific notice requirements, and a specific evidentiary standard. The court must find, based on substantial evidence, that the proposed ward lacks capacity, and that guardianship is the least restrictive alternative available. Bertram Foss's petition had 3 problems. The first was a notice deficiency. California law requires that a copy of the petition and the notice of hearing be personally served on the proposed ward at least 30 days before the hearing date. The petition listed a hearing date of January 14th. It had been served on me on December 19th. That was 26 days, not 30, 4 days short of the statutory minimum. This is the kind of error an estate planning attorney makes when he steps outside his lane. A litigator would have known. Foss did not know, or he knew, and believed that in a relatively uncontested matter the deficiency would not be raised. The second problem was in the capacity declaration. California Welfare and Institutions Code Section 5008 requires that a petition for conservatorship, the formal term for what Foss had filed, be supported by a declaration from a licensed healthcare professional who has personally evaluated the proposed conservatee within the past 6 months. Foss had attached a declaration from a Dr. Gerald Watts, a psychologist, describing an evaluation he claimed to have conducted in October. I know Dr. Gerald Watts. I interpreted for him in a dependency proceeding in 2019 when the mother in the case spoke only Spanish. He is a competent evaluator. I have no objection to Gerald Watts. What I object to is the date of his declaration. His declaration was dated November 3rd. It described an evaluation conducted on October 22nd, but the petition listed me as the subject of the evaluation by my full legal name, which is Miriam Abina Osai. In the declaration, Dr. Watts referred to the subject of his evaluation throughout as Miriam A. Osai Williams. Osai Williams was my name during my marriage to Charles. I legally reverted to Osai in 2019, a year after Charles died, because I wanted my father's name back, and I had earned the right to want things. All of my professional licenses, my identification, my court certifications, every document I have generated since 2019 lists me as Miriam Abina Osai. Dr. Watts had evaluated someone. Whether that someone was me, and whether the evaluation was therefore valid under the statutory requirement, was now a question that any competent opposing attorney could raise. The third error was the most interesting. Foss's petition alleged that I was unable to manage my financial affairs, citing as evidence a pattern of impulsive financial decisions and failure to maintain adequate records. It listed 3 specific examples. The first was a charitable contribution of $6,000 I had made to a scholarship fund at the community college where my father once taught. The second was a home repair expenditure of $11,000 for a roof that the petition described as unnecessary. The third was a failure to timely file certain tax documents. I have filed my taxes on time every year since 1981, with the exception of 2018, when Charles was dying, and for which I received an automatic extension that was properly documented and timely resolved. I have the records. I have always had the records. But more importantly, the petition cited the failure to timely file as occurring in the tax year 2023. I filed my 2023 taxes in February of 2024, 9 months before the petition was filed. The petition alleged a failure that had already been corrected, as a matter of public record, which Foss had apparently not checked. An estate planning attorney who did not check whether the deficiency he was citing still existed. 3 errors: the notice date, the name discrepancy in the evaluation, the resolved tax issue alleged as ongoing. I wrote them down in my own handwriting in a small green notebook I keep in the kitchen drawer for exactly this kind of thinking. I numbered them 1, 2, 3. I drew a line under each one and wrote, in the space below, "Do not use yet." Then I made dinner, called my sister in Accra, and went to bed. I have been asked since, by people who know the story, how I slept that night. I want to answer that honestly. I slept the way I always sleep, which is to say I do not sleep particularly well, and I have not since Charles died. But what I felt lying in the dark was not fear, and it was not even anger. What I felt was something I can only describe as the settling of a long professional instinct into a problem that, for once, was personal. For 30 years, I had sat beside other people in their worst moments and found the language to help them navigate systems designed without them in mind. I had done it calmly and precisely and without flinching, because that was the work, and the work was what I was good at. Now the system had turned toward me, and I found, in the dark of my bedroom, that I was not afraid of it. I knew every crack in that floor. I had been walking across it for 3 decades. The men who filed that petition had never once had to explain due process to a judge in 2 languages. I had done it 4,000 times. I was not confused. I was awake. I did not retain an attorney immediately. I want to explain why, because it is a decision some people will find strange, and it deserves a precise answer. I did not retain an attorney immediately because the first attorney I called, A woman named Patricia Sue, who had been recommended to me by a D's and who practiced probate litigation out of an office near the courthouse, told me something that changed my approach entirely. She said, "Miriam, if we file a response this week and challenge the notice deficiency, we win that motion, the petition gets refiled with a corrected date, and we start over. We don't get to use the deficiency again. We burn it." I said, "What if we don't challenge it yet?" She was quiet for a moment, the specific quiet of an attorney who is recalculating. "If we don't challenge it," she said carefully, "and the other side doesn't notice it, they proceed to the hearing on a defective filing. Anything that happens at a hearing on a defective filing is potentially voidable. We could move to vacate the entire proceeding after the fact." But she added, and her voice changed, "They might notice it before the hearing and refile. If they refile in time, we lose the advantage." I said, "How likely are they to notice it?" Another pause. "How old is Bertram Foss?" she asked. 63, I said. "Estate planning practice. I don't believe he's done a contested guardianship." The quiet this time lasted long enough that I knew she was making a decision. "You're not going to chase them," she said. "You're going to let them run." I said, "That's exactly right." Patricia Sue said, "I have been practicing probate litigation for 19 years, and I have never had a client say that to me in a first phone call. I told her about my father, about what he used to say. The truth is boring and it is patient. Liars are the ones in a hurry." She was quiet for another moment. "All right," she said. "We do this your way. But you call me every time they file anything, and I want to review every document before you respond to anything." I agreed. That was December 22nd. The holiday came and went. I spent Christmas with David and his family, which was uncomfortable in the way that things are uncomfortable when everyone in the room knows the thing that is not being said. Renata made a beautiful meal. The grandchildren were noisy and affectionate and innocent of all of it. I held the youngest one, a boy of 3 named Alu after his great-grandfather, and I thought about what it meant that his parents had filed a legal action to take control of my life. I did not let that thought reach my face. David mentioned, carefully, over dessert, that the attorney had said the process would be straightforward and quick, and that there was nothing to worry about and that it was all in my best interest. I said, "I know you believe that." He looked at me for a moment. There was something in his face that I am still not sure how to name. Not guilt, exactly. Something adjacent to it. The expression of a man who has told himself a story about his own motivations and has not yet been required to test whether the story is true. I looked at Alu, asleep now against my shoulder. I said, "He has my father's ears." David looked at his son, and his face changed into something softer, and I let it be soft, because there was time for the other thing, and that time was not Christmas. Michael called me on December 27th. This surprised me because Michael had not called me since November, which was itself unusual. He called in the evening, when Carla was presumably elsewhere, and he spoke carefully in the way of a man who has prepared what he wants to say. He said, "Mom, I want you to know I didn't want this." I said, "I know Michael." He said, "Renata said it was the right thing, that you were going to need help eventually, and it was better to have the structure in place." I said, "And what did you think?" He was quiet. I said, "You signed the petition, Michael." He said, "I know." I said, "You signed a legal document that said your mother is unable to manage her own affairs." "I know, Mom." I let him sit with that for a moment, not because I wanted to punish him, but because I wanted him to actually feel the weight of what the words meant. I had spent 30 years watching people sign documents without feeling the weight of the words, and then watching them understand the weight too late. He said, "I'm sorry." I said, "I know you are. I need you to listen to me carefully." He said he was listening. I said, "Don't do anything. Don't talk to David about calling it off. Don't call Foss. Don't say anything to Renata about having called me. You signed the document. Whatever happens now happens through the process, not through a phone call. Do you understand?" He said he understood. I said, "Good, I love you. Call me next week." He said he would. He sounded, when he hung up, like a man who had been hoping for something and had not received it and was not entirely sure whether that was a relief or a disappointment. That call told me two things. It told me that Michael's commitment to the petition was softer than David's. And it told me that Renata was the architect of the strategy in a way that David's name on the filing obscured. I put both of those facts in the green notebook, dated them, turned the page. January arrived, and with it the first motion from Foss's office. It was a request for an expedited psychological evaluation, filed January 3rd, 11 days before the scheduled hearing. The motion argued that given the stakes of the proceeding and the complexity of the proposed ward's financial situation, an independent court-appointed evaluator should examine me before the hearing to provide the court with current, objective information about my cognitive status. Patricia reviewed it and called me the same evening. "He's trying to get ahead of the name problem," she said. "He may have noticed the Osai Williams issue in the Watts declaration, and he's trying to get a clean evaluation in before the hearing rather than risk the declaration being challenged." I asked whether we should oppose the motion. She thought about it. "If we oppose it," she said, "we signal that we're watching the declaration closely. He'll understand why we're watching it, and he'll withdraw and refile with a corrected declaration, and we lose the advantage. If we don't oppose it," she said, "he gets his evaluation. But we get to see who he requests as the evaluator, and depending on who it is." I said, "Request Dr. Christina Samo." A pause. "You know her." I said, "I interpreted for her in 3 dependency hearings between 2016 and 2020. She is the best cognitive evaluator in Riverside County, and she does not make mistakes in either direction. She will find exactly what is there and nothing else." Patricia was quiet for a moment. "Is that a risk?" I said, "Only if I'm actually confused." Another pause, then a sound that might have been a laugh contained at the last moment. "I'll file the non-opposition with a preference request for Dr. Asamo," Patricia said. Foss agreed to the evaluator without objection, which told me either that he did not know Dr. Asamo's work or that he assumed any evaluator would find what he expected them to find. The evaluation was scheduled for January 9th, 5 days before the hearing. I want to tell you about that evaluation. Not to prove anything, the results will speak for themselves, but because what happened in that room is the center of this story in a way that no courtroom scene can quite replicate. Because what happened, there was not a legal proceeding. It was a woman sitting across from another woman and being required to demonstrate, in controlled conditions, that she was still herself. Dr. Christine Asamo arrived at my house at 9 in the morning. She is 51 years old, compact and precise, with the quality of attention that I associate with people who have spent their careers listening to what is not being said as much as what is. She sat up at my kitchen table with her materials and her recording device, and she looked at me for a moment before she began, and she said, in the specific, careful tone of a professional who has done this many times and understands the particular indignity of it, "Mrs. Osai, I want you to know that I conduct these evaluations the same way regardless of who requested them or why. My obligation is to the court and to an accurate assessment, nothing else." I said, "I know. I interpreted for you in the Martinez dependency proceeding in 2017, and again in the Lebrun matter in 2019 and the Castellano hearing in 2020. She looked at me for a moment without speaking. Then she said, "I remember the Martinez case. The grandmother spoke only Creole and she stopped. She looked at me again, differently this time, more carefully. She said, "You were the interpreter." I said, "For 30 years. She was quiet for a moment. Then she picked up her pen and made a note on her intake sheet and said, still with perfect professional composure, "Let's begin." The evaluation lasted 4 hours. I will not walk you through every component because cognitive assessments are not designed to be entertaining, and because the specifics are less important than the shape of what happened. What I will tell you is that the assessment covered memory, executive function, language processing, orientation, abstract reasoning, and what Dr. Asamo's field calls instrumental activities of daily living, which is a clinical way of asking, whether a person can manage the practical components of an independent life. I answered every question. I completed every task. I did not perform or embellish or try to demonstrate anything beyond what the questions were actually asking for, because Dr. Asamo has spent 20 years identifying performance, and I had no interest in confusing my actual cognition with the appearance of it. There was one moment I want to tell you about, because it was the moment the evaluation became something other than a professional procedure. Toward the end of the session, Dr. Asamo administered what is called a verbal fluency test, in which the subject is asked to name as many items as possible from a given category within 60 seconds. She asked me to name animals. I named 41 animals in 60 seconds, including several in Spanish and one in Haitian Creole, which I added because the Creole word for flamingo is more beautiful than the English one, and I have always believed that beauty should be introduced when the opportunity presents itself. Dr. Asamo looked up from her notes. She said, "The clinical threshold for this assessment is 14 items." I said, "I know. I've watched you administer it." She looked at me for a long moment, and for the first time in the 4 hours we had been sitting at my kitchen table, something shifted in her face that was not professional but was something older and less structured. Something that looked, if I had to name it, like recognition. She said, "How are you doing, Mrs. Osai?" Not the assessment. How are you actually doing? I thought about that question for a moment. I thought about the green notebook in the kitchen drawer. I thought about Michael on the phone, sounding like a man standing at the edge of something he was not sure he wanted to step off. I thought about Alu, asleep against my shoulder on Christmas, with my father's ears. I said, "I am doing what I have always done. I am paying close attention, and I am taking careful notes, and I am waiting for the right moment." She held my gaze for a moment. Then she wrote something on her intake sheet that I could not read from where I was sitting. She closed the file. She said, "I'll have my report to the court by January 12th. I walked her to the door. She shook my hand the way you shake the hand of someone you have understood something about that you did not expect to understand when you arrived. I went back to the kitchen, sat down at the table, and wrote in the green notebook, "Evaluation complete. Dr. Asamo understands what she found." Then I turned to a clean page and wrote the date, and underneath it, 11 days before the hearing. Foss has not noticed the notice deficiency. He has not refiled. He is proceeding on the original petition. The ladder is getting taller. I went to make coffee and noticed, as I often do, that the kitchen still has the particular quality of a room that was shared for 31 years by 2 people who knew how to be in the same space without crowding each other. Charles used to stand at that counter in the morning with his coffee, and the newspaper folded in quarters, because he said the full broadsheet was an act of aggression in a small kitchen. I stood in his spot for a moment. I said out loud to the room, "I have this, Charles." Then I poured my coffee and went to read Foss's latest filing. Dr. Asamo's report arrived at the court on January 12th, 2 days before the hearing, and Patricia called me within an hour of receiving the copy. "I am going to read you the summary paragraph," she said. "Are you ready?" I said I was. She read, "The proposed conservatee, Miriam Abina Osai, demonstrates cognitive functioning well above the normative range for her age cohort across all assessed domains. Her verbal fluency, executive function, working memory, and abstract reasoning are not merely within normal limits, but are in the superior range, consistent with her professional background and self-reported history of high-demand cognitive work. There is no clinical evidence of cognitive decline, impaired judgment, or diminished capacity in any domain assessed. This evaluator finds no basis, on clinical grounds, to support a petition for conservatorship of the person or the estate of Miriam Abina Osai." Patricia stopped reading. I said, "Good." She said, "Miriam, the language here is unusually strong. She essentially said you're sharper than most people half your age." I said, "She is an accurate evaluator." Patricia laughed. Actually laughed this time, not the contained sound from before. She said, "Do you want to know what Foss filed this morning?" I said, "What did Foss file this morning?" "A supplemental declaration from Dr. Watts, she said, correcting the name issue. He noticed, finally. But he filed the corrected declaration this morning, 2 days before the hearing, which is, she paused, procedurally sloppy. The rules on supplemental declarations in probate proceedings require 7 days' notice to the opposing party before the hearing. He's filed this 2 days out. So, I said, he has now filed a defective original declaration that used the wrong name, which he tried to correct with a supplemental declaration that was filed outside the required notice period. Yes, Patricia said. Which is a second procedural error, I said. A significant one, Patricia said. I said, and the notice deficiency from the original filing is still unaddressed. Still unaddressed, Patricia confirmed. He never refiled. The original petition goes to hearing on January 14th with a defective service date. I sat with that for a moment. Patricia said, Miriam, we have the evaluation. We have 2 procedural deficiencies. We have a corrected declaration that was filed too late. We can go to that hearing and end this in the first 30 minutes. I said, I know. She said, so we're ready. I said, we're ready. She said, can I ask you something? I said she could. Did you know this was how it was going to go when you told me to let them run? I thought about that honestly. I knew they had made errors, I said. I knew Foss was out of his depth. I suspected they would keep making errors if I gave them room. But I didn't know about Hargrove Properties then. I didn't know about the developer. I found that out later. How? She asked. I said, someone left an email open on a computer I was not supposed to be using. A pause. Tell me, Patricia said. I told her. It had been a week earlier, on January 6th. David had asked me to come to his house to have what he called a family conversation about the situation, which I understood to mean a conversation in which he would attempt to persuade me to accept the conservatorship voluntarily and avoid the hearing. I went because I believed it was important to understand what David actually thought, as opposed to what Renata had organized him to think. I arrived at 4 in the afternoon. Renata was not there, which I noted. David made tea and sat across from me at the kitchen table that I had helped them pick out at a furniture store in 2014, and he spoke carefully and with evident discomfort about how much he loved me and how worried he was, and how the evaluation was just a formality, and how Foss had said the process would be smooth and quick, and how it was all really about protecting me. I listened. I did not argue. I did not challenge a single statement he made, because the point of the conversation was not to change David's mind in his own kitchen on a Tuesday afternoon. The point was to understand what he believed and why. He believed, I came to understand over the course of that conversation, that he was doing the right thing. He had told himself a story that had Renata's fingerprints all over it, that Miriam is getting older, and the house is too big, and the maintenance is becoming a burden, and wouldn't it be easier for everyone if there were a structure in place? And he had inhabited that story so completely that he had ceased to examine it. I felt, listening to him, the particular sadness of watching someone who loves you misunderstand their own motivations in real time. While David was in the kitchen refilling the tea kettle, I walked to the small desk in the corner of the living room where he keeps his home computer. I was not snooping. I was walking past it and I saw on the open screen an email thread. The thread was between Renata and a man named Paul Cleary, acquisitions director at Hargrove Properties. I read 3 paragraphs. I did not copy them. I did not photograph them. I memorized them the way I had memorized legal terminology in 3 languages over 30 years, word for word, the way my father taught me to memorize things that mattered. Then I walked back to the sofa and sat down, and when David returned with the tea, I accepted the cup and listened to the rest of what he had to say. When I left that evening, I drove home carefully, the way you drive when your mind is doing something important and you want to give your hands the task of steering so the rest of you can work. I sat at the kitchen table, and I wrote what I had memorized in the green notebook. Paul, timeline update. We believe the evaluation will confirm what we need. Attorney says hearing is formality. Once conservatorship is in place, we can have the conversation about the property with the conservator present. Legal says the facilitation arrangement is clean as long as the property transfer is arm's length, targeting Q2 for the initial approach. 3 paragraphs, memorized clean. I read them back to myself, and then I sat for a long time in the quiet kitchen. There it was, not suspicion, not inference. The reason, in Renata's own words, in an email she had written without knowing I would ever see it. Facilitation arrangement, Q2, once conservatorship is in place. I wrote the date beside the text. I wrote, sourced from memory, seen on David's home computer, do not use as evidence. Find the document through proper channels. Then I called Patricia. She said, how do you want to find it? I said, discovery. If we get past the hearing with the petition intact, we request discovery and we subpoena Renata's emails. But that's only if we need to. She said, why would we need to? I said, because the petition may survive January 14th. She said, Miriam, between the evaluation, the notice deficiency, and the declaration problem, I cannot see a scenario in which this petition survives January 14th. I said, neither can I, but I want the option. I want to know we can find that email through proper channels if the hearing goes wrong. She was quiet. Then she said, you're planning for a world where we lose. I said, I always plan for a world where we lose. I spent 30 years in courtrooms watching people who didn't. She said, all right, I'll structure discovery requests now. If the hearing goes the way I think it will, we won't need them, but they'll be ready. Good, I said. She said, what is the email worth to you, even if you don't need it to win the hearing? I thought about that. It's worth everything, I said. Not for the hearing, for David. A pause. You want him to understand why it happened, she said. I said, I want him to see what was actually driving the decision that he agreed to put his name on. I want him to read his wife's email and understand what he was being used for. You could be wrong about Renata, Patricia said carefully, about how much she knew. I said, I know what I read. Patricia was quiet for a long moment. All right, she said. Discovery requests will be ready Thursday. I thanked her and hung up and sat in the quiet for a while longer. I thought about David at 22, graduating from engineering school, standing in a too large suit with his diploma and the specific combination of pride and uncertainty that I have always loved in him. I thought about the way he used to call me on Sunday afternoons just to talk, about nothing in particular, about the week and the weather and something funny Alu had said. I thought about what it was going to cost him to understand what he had signed his name to. I picked up the green notebook. I wrote, the truth is the kindest thing I can give him, even when it isn't kind. Then I closed the notebook and went to bed. The morning of the hearing, I dressed in the suit I wore for my final day of work in October. It is a deep blue wool suit that I bought in 2019, the year I went back to my own name, the year I decided that if I was going to reclaim myself, I was going to do it completely. It has the particular quality of a thing chosen rather than inherited. I wore it because I wanted to walk into that courthouse looking like what I am, which is a woman who has spent 30 years in that building, being taken seriously by every judge on that bench. Patricia met me in the lobby at 8:30. She is 54, silver-haired, with the quality of contained alertness that the best litigators have, the sense that she is always processing slightly faster than the conversation requires. She said, Foss is here. He's brought a second attorney, a younger man I don't recognize. Probably local counsel he called in when he saw the evaluation. I said, he read the evaluation and panicked. She said, that's my assessment. I said, good, panic makes people sloppy. She looked at me for a moment. She said, you are remarkably calm. I said, I interpreted the Morales criminal trial in 2011. 3 weeks. Attempted murder charge. The defendant spoke only Creole, and the prosecution's key witness spoke only Spanish, and I was the only interpreter present who could handle both. If I had not been calm, that man would have been convicted on testimony he could not hear in a language he did not speak. Patricia looked at me. She said, what happened? He was acquitted, I said. She said, because of the interpretation. I said, because the interpretation was accurate and accuracy matters. We walked into the courtroom. The courtroom was the same one I had interpreted in more times than I could count. Department 12, Judge Adami Lawson, Probate and Family Matters, a man I had worked alongside for 11 years, without either of us ever having a direct conversation that was not filtered through the court's business. He looked up when Patricia and I entered and took our seats at the respondent's table. He looked at me. He said, "Interpreter Osai." I said, "Good morning, Your Honor." He said, "I did not know you were involved in this proceeding." I said, "I am the respondent, Your Honor." He sat back very slightly, a small movement, the movement of a man recalibrating something. He said, "I see." He looked at Foss's table for a moment. Foss was a tall man with the slightly rumpled quality of someone who had dressed hurriedly or was trying to appear approachable and had misjudged the balance. The younger attorney beside him was in a sharper suit and kept his eyes on his papers. Judge Lawson said, "Let's proceed." Foss stood. He had clearly spent time on his opening, which had the quality of something rehearsed rather than thought. He described my retirement as a transition that had left a capable and accomplished woman without the structure that had previously organized her life. He described the concerns of my family as arising from love and genuine worry. He cited the charitable contribution and the roof repair as evidence of impulsive financial behavior. He did not mention the tax issue, which told me he had realized, at some point between filing and this morning, that the tax issue was not going to survive 5 minutes of examination. He cited Dr. Watts's declaration, the corrected one. Patricia stood. "Your Honor," she said, "before the petitioner continues, I'd like to raise a preliminary matter regarding the adequacy of the petition and the notice of hearing." Voss stopped. Judge Lawson said, "Go ahead, Ms. Sue." Patricia said, "The petition was filed on December 19th. The hearing is scheduled for today, January 14th. That is 26 calendar days. California Welfare and Institutions Code Section 1822 requires a minimum of 30 calendar days notice of hearing to the proposed conservatee. The petitioner is 4 days short of the statutory minimum." Voss stood up. "Your Honor." Judge Lawson raised one finger. He did not look at Foss. He looked at the petition on his desk. He leafed through it quietly. He said, "Ms. Sue, what is the respondent's position on this deficiency?" Patricia said, "The respondent respectfully moves to dismiss the petition on grounds of defective service. The notice requirement exists to ensure the proposed conservatee has adequate time to prepare a defense. 4 days is not a technical shortfall. It is a material deprivation of due process." Foss said, "Your Honor, the respondent's attorney received all filings timely and clearly had adequate time to prepare, as evidenced by her presence here today with a full response package." Judge Lawson looked at Foss. He said, "Mr. Foss, the statutory requirement is not about whether the attorney had time to prepare. It is about whether the proposed conservatee had the notice the law requires. The question is not whether Ms. Sue was ready. The question is whether the petition was properly served." He looked at the petition again. He looked at the date. He said, "The petition is defective on its face. The notice was 4 days short of the mandatory minimum." Foss said, "Your Honor, we would ask the court to exercise its discretion to overlook a minor technical." Judge Lawson said, "A 4-day shortfall in the notice period for a proceeding to deprive an adult of control over her own life and finances is not a minor technical deficiency, Mr. Foss." The courtroom was very quiet. Judge Lawson said, "Is there anything further you'd like to raise before I rule on the motion to dismiss?" Patricia said, "Yes, Your Honor. In the event the court exercises discretion to allow the petitioner to refile, the respondent would also note for the record that the supporting declaration from Dr. Gerald Watts, as originally filed, referred to the proposed conservatee throughout as Miriam A. Osai Williams, which has not been the respondent's legal name since 2019. The petitioner filed a corrected supplemental declaration on January 12th, 2 days ago, which is outside the 7-day notice requirement for supplemental declarations in probate proceedings under Local Rule 4. 1. The corrected declaration is therefore procedurally deficient as well. Another silence. Foss's younger colleague was writing rapidly on a notepad. Foss himself had the expression of a man who has walked into a room and found that the furniture has been rearranged, and he cannot find where anything is. Judge Lawson said, "Mr. Foss, you filed a petition for conservatorship of a proposed conservatee whose legal name you had wrong. You filed a corrected declaration 2 days before the hearing in violation of the Supplemental Declaration Notice Rule, and the original petition was served 4 days short of the statutory minimum." He set down the petition. He said, "This proceeding is dismissed without prejudice. The petitioner may refile with a corrected petition and proper notice if he chooses to do so. Before doing so, I would strongly recommend that petitioner's counsel familiarize himself with the procedural requirements for contested conservatorship proceedings, which are not the same as those for uncontested estate planning matters." He looked over his glasses at Foss. He said, "I have known interpreter Osai for 11 years. I have watched her ensure that defendants who did not speak English understood every word said to them in my colleagues' courtrooms. I am aware that this observation is not a legal basis for ruling, and I want to be clear that my ruling rests entirely on the procedural record. But I would encourage petitioner's counsel to consider carefully whether refiling this petition is in anyone's actual interest." He closed the file. "Dismissed," he said. "MS. Sue, please prepare an order." He looked at me for one moment, directly, the way you look at someone you have seen do difficult work over a long time. He said, "Good morning, interpreter Osai." I said, "Good morning, Your Honor." And that was the first courtroom. I want to tell you there was a moment of triumph in the hallway. There was not. What there was, in the corridor outside Department 12 on a January morning, with the particular institutional light of a courthouse falling through high windows onto linoleum floors I had walked across for 30 years, was something quieter and more complicated than triumph. Patricia said, "That was clean. That was very clean." I said, "He was well prepared to understand procedural arguments." She said, "Because you spent 30 years in his courthouse." I said, "That helped." She looked at me. She said, "What now?" I said, "Now I call my sons." She said, "Not together." I said, "No, Michael first, then David." She said, "And Renata." I thought about the email, about Paul Cleary, acquisitions director, about Q2 and the facilitation arrangement and the conversation to be had with the conservator present. I said, "Renata later, when David has read the email." Patricia looked at me carefully. She said, "You're going to use the discovery." I said, "I'm going to request it, yes." She said, "Even though the petition is dismissed." I said, "The petition is dismissed without prejudice. They can refile. And even if they don't, David needs to know what his wife was doing with his name. Not for the case, for him." She was quiet. She said, "That's not legal strategy." I said, "No, it's something else." She looked at me for a long moment. The kind of look that is not agreement exactly, but is the look of a woman who understands what is being done and why, and is not going to argue with it. She said, "I'll send the discovery requests this afternoon." I said, "Thank you, Patricia." She shook my hand and walked toward the elevator, already on her phone. I stood for a moment in the corridor of Department 12. I had stood in this corridor more times than I could count, on the way in and on the way out, carrying the words of people who needed them carried. I had stood here in the mornings before difficult hearings, and in the afternoons after long trials, and once, in 2014, in the middle of a case that had gone badly, and that had required me to interpret a mother's loss in 2 languages in real time, without letting my voice break. I had stood here, and I had been good at what I was asked to do. Now I was done being asked. I put on my coat. I walked to the elevator. I pressed the button for the lobby. The courthouse smelled the way courthouses always smell, of paper and floor wax, and the particular compressed urgency of too many serious things happening in one building at once. I breathed it in one more time. Then the elevator doors opened, and I walked out into the January light. The discovery request went out on January 15th, the day after the hearing. Patricia was precise and narrow in her scope. She requested only the emails between Renata and Hargrove properties related to the property at my address, and only the correspondence with Bertram Foss's office related to the initiation of the conservatorship proceeding. She did not ask for anything broader. A broad request is easy to fight. A narrow, specific request that lands exactly on the documents you know exist is much harder to deflect. Renata's attorney, she retained her own, separate from Foss, which told me something, filed an objection on privacy grounds within 48 hours. Patricia had anticipated this. She filed a response citing the fraud exception to the marital communications privilege and the fiduciary duty exception applicable in cases where documents are relevant to an alleged scheme to deprive someone of property rights through a legal proceeding. The discovery dispute went to a hearing on January 28th. I was not in the room for that hearing. Patricia was. She called me afterward. She said he granted it. Narrowly, but he granted it. We get the Hargrove correspondence and the Foss correspondence. Renata's attorney has 10 days to produce. I said, how did Renata look? Patricia said, I don't know how to read Renata. She has excellent composure. I said, I know, she always has. Patricia said, the attorney tried one more argument. He said the Hargrove correspondence predated the conservatorship filing by 7 months and therefore couldn't be related to a scheme that hadn't been initiated yet. I said, and she said, Judge said the relevance of prior correspondence to the motivations behind a subsequent legal filing is a factual question, not a legal one, and the documents go to that factual question. Good, I said. Patricia said, Miriam, when those documents come in, what are you going to do with them? I thought about that. I said, I'm going to give them to David. She said, before you do anything else with them. I said, yes. She was quiet. She said, not the press, not the state bar complaint about Foss, not the real estate board. I said, not yet, David first. She said, why? I thought about Charles standing at the kitchen counter with his coffee and his newspaper folded in quarters. I thought about Alu with my father's ears. I thought about David at 22 in his too large suit and the way he still called on Sunday afternoons even now, even through all of this, because the habit of love is more durable than most other things. I said, because he is my son, and I want him to understand what happened from me, not from a news story or a bar complaint or a real estate board finding. I want him to read the email, and I want to be there when he reads it, and I want him to be able to ask me whatever he needs to ask. Patricia was quiet for a long time. Then she said, all right, 10 days for the production, then we'll talk again. I thanked her and hung up. I called Michael that evening. He answered on the second ring, the way he always answers when he knows it might be important. I told him the petition had been dismissed. I told him why. I told him about the notice deficiency and the declaration error and what Judge Lawson had said. He was quiet for a long time. Then he said, Mom, I'm sorry. I said, I know. He said, what happens now? I said, now you let me handle it. Can you do that? He said he could. I said, Michael, do you trust me? He said, I have always trusted you. I said, then let me finish this, and when it's finished, I'll tell you everything. He said, all right. He said, is David going to know what I told you, that I called in December? I thought about that. I said, David is going to know what's in the documents. That's enough. He was quiet. He said, Carla wants to know if you'll come for dinner Sunday. I said I would come for dinner Sunday. He said, she's making jollof. I said, tell her to make enough. He laughed, the particular laugh of a man who has been holding something tight for 2 months and has been given permission to put it down for a moment. I said goodnight and hung up. I sat in the quiet kitchen for a while. Then I went to make dinner, and the lemon tree in the backyard was visible through the kitchen window in the January dark, bare of leaves but present, the way things you have lived with for a long time are present even when they offer you nothing. I thought, spring is coming. I thought, let it come. The documents from the Discovery production arrived at Patricia's office on February 7th. She forwarded them to me the same evening. I printed them at the kitchen table in the particular quiet of a house at 9 o'clock at night and I read them the way I read everything that matters, which is slowly and twice, and with a pencil in my hand. There were 43 emails between Renata and Paul Cleary of Hargrove Properties. The earliest was dated April 3rd of the previous year, 7 months before I retired, 11 months before the hearing. The latest was dated January 6th, the day I had sat in David's living room and drunk his tea and let him tell me about protecting me. That last email, the one from January 6th, read in full, Paul, update from this evening. She came for the conversation. Didn't push back the way I expected. Hearing is January 14. Once it's resolved, we can move to the next step. Still confident on Q2. She came for the conversation. Didn't push back the way I expected. I sat with that sentence for a long time. She had expected me to push back. She had prepared for a fight on David's couch, and I had given her nothing, just tea and listening and a quiet agreement to let the process run. She had read that as weakness. She had emailed her developer contact the same evening to confirm they were still on track. My silence about what I knew had let her believe the thing she needed to believe to keep building. There was a thread from June, 2 months after the first Hargrove contact, in which Renata outlined what she called the family situation. She described me as capable, but isolated and likely to resist any voluntary arrangement. She described David as on board in principle but needing time. She described Michael as a complication. Michael as a complication. I wrote that in the notebook, underlined it, not for evidence, because I wanted to remember it. Because Michael, the complication, had called me on December 27th to say he was sorry, and I wanted to hold both of those facts at once. There was an email from August in which Renata told Cleary that she had identified an attorney. She described Foss as suitable for an uncontested matter, and noted that she did not anticipate significant resistance given the subject's age and the family's unified position. The family's unified position. I thought about Michael's face the last time I had seen him, at Christmas, carefully not looking at his brother and not looking at his mother, and keeping his attention on Alu and the food and the middle distance, where the difficult thing was not located. Not unified, divided by the width of one phone call. I read all 43 emails. I made notes. I organized them by date and subject and noted the relevant sections with a small asterisk in the margin, the way I had learned to mark important passages in 30 years of legal documents. Then I called Patricia. She said, "You've read them." I said, "All of them." She said, "What do you want to do?" I said, "I want to meet with David on Saturday. I want you to prepare a packet of the relevant emails. 12, maybe 15 of them, the key thread." She said, "The state bar complaint against Foss." I said, "Yes, but not yet." She said, "The real estate licensing board regarding Renata." I said, "Yes, also not yet." She said, "Miriam." I said, "Patricia. My son is going to read an email that his wife wrote on the evening she sat across from me and watched me drink tea she had made with the intention of taking my home. He's going to read that email and understand, for the first time, what he had his name put on. He needs to do that before anything else happens." Silence. She said, "And if he still sides with her?" I said, "Then I will know that too. And the bar complaint and the board complaint will proceed the following Monday." She said, "You're giving him the chance to choose." I said, "He's my son. That's what you do." She said, "All right, I'll prepare the packet." I said, "Thank you." She said, "Miriam, you know what these emails mean for the conservatorship petition if they refile." I said, "I know." She said, "They can't refile. The moment these emails are in evidence, any refiled petition carries the taint of the motivation. No judge in this county is going to entertain a conservatorship proceeding once it's established that the motivation was a property development arrangement." I said, "I know." She said, "So it's over as a legal matter." I said, "It's over as a legal matter." She said, "But you're still meeting with David on Saturday." I said, "Yes." She said, "Because the legal matter isn't the point." I said, "It never was." I called David on Thursday. I said, "I'd like to come on Saturday. Just us. Is Renata going to be home?" He said she was taking Alu to a birthday party in the afternoon. I said, 2 o'clock. He said 2 o'clock was fine. He said, Mom, is everything all right? I said, everything is all right. I'll see you Saturday. I spent Friday in the garden. The January cold had done what January cold does to the lemon tree, which is nothing. Lemon trees do not yield to January, and never have in my experience. I pruned the lower branches and turned the soil around the base, and did the maintenance work of a woman who intends to be in the same garden in 5 years and in 10. Carla called in the afternoon to ask if I needed anything. I said, how is Michael? She said, he's been better since you talked. He's been sleeping. I said, good. She said, Miriam, he's not going to be angry at you. Whatever happens with David, he's not going to blame you. I said, I know. She said, good. Are you coming Sunday for Jollof? I said, I am coming Sunday for Jollof. She said, good, I'm making enough. I said goodbye and went inside and stood in the kitchen and thought about the 2 sons I had raised in this house, and the different men they had become, and the different ways they loved me, and how all of it, the petition, the emails, the hearing, the green notebook, was going to end the way it was going to end, which was with me still standing in this kitchen and the lemon tree still in the garden. I was not confused about that. Not for one moment. Saturday. David opened the door before I knocked. He had the expression he has worn since childhood when he knows something serious is about to happen, and he is not certain whether he is ready for it, which is a kind of open, effortful attentiveness that I have always loved in him, even when it is aimed at me in the wrong direction. I came in. He took my coat. We sat in the living room, not the kitchen, which told me he had thought about the setting and decided the living room was more formal, more suitable for a serious conversation. He had not made tea. I set the folder Patricia had prepared on the coffee table between us. I said, I need you to read something. He looked at the folder. He said, what is it? I said, it's an email correspondence between Renata and a development company called Hargrove Properties. It covers a period of about 10 months. The first email is from April of last year. The last one is from January 6th, the evening I came here for tea. He was very still. I said, I am not going to tell you what to think about what you read. I'm going to sit here while you read it, and when you're done you can say whatever you want to say. He said, Mom. I said, David, read it. He picked up the folder. I watched him read. I have watched a great many people read important documents over 30 years. I know what it looks like when understanding arrives in stages, when a person moves from reading to absorbing to reckoning. I have watched defendants read plea agreements and parents read dependency petitions and heirs read wills that said something other than what they expected. I watched my son read. He got to the email from August, the one about Foss, the one that called him suitable for an uncontested matter, and something in his face shifted. He went back and read it again. He read it a 3rd time. He kept reading. When he got to January 6th, she came for the conversation, didn't push back the way I expected, still confident on Q2, he stopped. He set the folder down. He looked at the table, not at me, at the table. I said nothing. I waited. I have always been good at waiting. After a long time, he said, How long have you had these? I said, The Discovery production came February 7th. I've had them for 6 days. He said, You've known for 6 days and you didn't. He stopped. He said, You came here on January 6th. I said, Yes. He said, You already knew about Hargrove by then, or... I said, I saw an email on your computer that evening. I didn't have the documents. I memorized what I saw. He looked up from the table, at me, for the first time since I had walked in. He said, You memorized the email. I said, I've been memorizing legal documents for 30 years. He looked at me for a long time. He said, Why didn't you say something, that night, when you were sitting right here? I said, Because saying something would have given you time to prepare, to defend, to talk to Renata and agree on a story. I wanted you to read the documents without warning, the way I read them, so you would feel the same thing I felt when I understood what was happening. He said, Which was what? I thought about the feeling. I said, like the person I trusted most in the room had been counting something I didn't know was being counted. He looked at me. He said, that's... He stopped. He said, I didn't know, Mom, about Hargrove. I didn't know about the emails. Renata said the property might eventually be worth something to a developer and that it made sense to have your affairs in order. I thought. He stopped again. I said, what did you think, David? He said, I thought it was about you. I thought I was worried about you. I said, were you? He looked at the table again. He said, yes, not the way the petition made it sound, but I worry about you alone in that house. I worry since Dad died. I worry. He stopped. He said, Renata said the legal structure would protect you. That having a conservator in place was just prudent. I didn't ask enough questions about why she wanted it done so fast, or why Foss, or... He stopped. I said, no. He said, I should have. I said, yes. We sat in the quiet of his living room for a while. Outside, I could hear the neighborhood, a lawn mower somewhere, a car going past, the ordinary sounds of a Saturday afternoon in January. I said, I want to tell you what I need from you. He looked up. I said, I need you to understand what your name was used for, not to punish you. Not because I'm angry at you, though I want to be honest. I am angry at you, David, and I think you need to hold that rather than argue with it. He nodded. I said, I need you to call Foss on Monday and tell him there will be no refiled petition. Not because of the legal situation, though the legal situation makes refiling impossible. Because you are telling him it is over. He said, all right. I said, and I need you to talk to Renata. He looked at me. I said, not about what to do. I'm not going to tell you what to do about your marriage. But I need you to talk to her about what she did, and I need that conversation to happen without you deciding in advance what you're going to believe. You need to ask her the questions and listen to the answers and decide for yourself what you think. He said, what do you think I'm going to find? I said, I think you're going to find that she made decisions with your name on them without telling you the full reason. What you decide to do with that is between you and her. But you deserve the conversation, and she deserves to be asked directly. He was quiet. He said, Mom, I put you through this. I said, you put your name on a document someone else prepared. He said, that's the same thing. I said, in law, yes. In a marriage, that's a question worth asking. He looked at the folder on the coffee table for a moment. He said, are you going to the bar complaint against Foss? I said, yes. He said, and Renata, the real estate board. I said, I haven't decided yet. He looked at me. He said, what would change your mind? I thought about that. I said, knowing that you've had the conversation, that you've actually asked her, that she's been required to account for what she did. He said, she won't admit it. I said, I know, but you'll know the truth after the conversation, and she'll know that you know, and that is a different thing than neither of you knowing. He was quiet for a long time. Then he said, I'm sorry, Mom. I said, I know you are. He said, I mean it. I said, I know you mean it. I also know it's not enough by itself. What makes it enough is what you do next. He nodded. He looked like a man who has had something clarified that he had been trying not to clarify for a long time, and who is not sure whether he feels better or worse for the clarity, but who understands that the clarity is not going back to where it came from. I picked up my coat. He walked me to the door. He said, at the door, in a quieter voice than he had used for the rest of the conversation, "Are we, is this?" He didn't finish. I said, "You're my son. That doesn't change. None of this changes that." He looked at me the way he used to look at me when he was 7 years old, and had done something he didn't know was wrong, and had been shown why it was wrong, and was trying to understand how he was going to carry it. I said, "Come for dinner next Sunday. Carla is making jollof and there will be enough." He said, "Okay." I said, "Bring Alu." He said, "Okay." I kissed his cheek and I walked to my car, and I drove home through the January afternoon with the particular quality of light that comes when the year is still new and everything that happened in the previous year, is exactly far enough behind you to begin to be legible. I pulled into my driveway. I sat for a moment looking at the house. My house. The house Charles bought in 1987 and left to me outright, and which I have been in for 34 years, and which no development company with a facilitation fee and a Q2 target is going to take from me. I got out of the car. I went inside. I made coffee. I sat at the kitchen table, and I opened the green notebook to a clean page, and I wrote the date. Then I wrote, "The petition is dismissed. The documents are produced. David has read the emails. The conversation has been had." I sat for a moment. Then I wrote, "The truth was patient." Then I put the cap back on the pen and closed the notebook and sat in the quiet kitchen with my coffee for a long time, listening to the house make the small sounds a house makes when it is accustomed to you and does not need you to do anything in particular, only to be there. What came after is perhaps less dramatic than what came before, and I want to tell you about it honestly because the drama of a story like this one lives in the middle, in the hearing and the documents and the green notebook, and what comes after is quieter and harder and more real. Foss received David's call on Monday. Patricia confirmed with the court that no refiled petition was incoming. She filed the bar complaint against Foss on Wednesday, citing his procedural errors and the evidence that the petition was filed in furtherance of a scheme to deprive me of property rights. The bar complaint is, as of the time I am telling you this story, under review. The real estate board complaint against Renata I did not file. I want to explain that decision because it is the one people find hardest to understand. I did not file it because David had the conversation with Renata. He told me about it 2 weeks after my visit in a phone call that lasted an hour and a half, and that was one of the most difficult conversations I have had with my son since Charles died. Renata had not admitted the intent directly. She had argued that the Hargrove correspondence was preliminary and speculative, and that the conservatorship had been in my best interest regardless of any property considerations. David had said, "Renata, I read the emails." She had been quiet for a long time. Then she had said, "I thought it would all work out." That is not an admission. It is also not a denial. It is the statement of a woman who had told herself a story, the way David told himself a story, and who was now confronted with the gap between the story and what the documents said. I thought about that for a long time. I thought about what filing the board complaint would do to Renata's career, and to David's marriage, and to the children who had nothing to do with any of it, including Alu with my father's ears. I thought about what my father used to say about the difference between justice and punishment. He said they were not the same thing. He said that justice was the truth being accurately recorded, and the record being available to anyone who needed to read it. He said punishment was something you did because you were angry, and that anger was a legitimate feeling, but a poor legal standard. The bar complaint on Foss is justice. Foss filed a defective petition in furtherance of a scheme he may or may not have fully understood, and he needs to answer for his professional conduct. The board complaint on Renata would be punishment, and I found that I did not have the appetite for it that I had expected to have, because the person who would suffer most visibly was not Renata alone. I am not certain it was the right decision. I hold that uncertainty. What I know is that it was my decision to make. Not David's, not Patricia's, not the board's, mine. That is the thing about managing your own affairs. You have to live with the choices. Michael came for jollof on the Sunday after I visited David. He arrived before David did, which was typical and comfortable, and he sat at my kitchen table and helped me cut vegetables and did not ask me anything directly because Michael knows when questions are the right tool and when presence is the right tool, and has always been better at choosing between them than his brother. David came an hour later with Renata and Alu. Renata came into my kitchen and looked at me. I looked back at her. She said, "Miriam." I said, "Renata." She looked at the table, the way David looks at the table when he is sorting through something difficult. She said, quietly enough that only I could hear, "I told myself it was in your interest." I said, "I know you did." She said, "I should have asked you." I said, "Yes." She looked at me for a moment. I said, "Come and help me with the rice." She came and helped me with the rice. We worked in the kitchen together in the particular quiet of two women who understand each other better than they have before, and who are deciding, without words, whether that understanding is going to make things better or worse or simply different. I think it is going to make them different. I cannot tell you yet whether different is better. Ask me in a year. Alu ran into the kitchen with the specific headlong momentum of a 3-year-old who has been outside and has brought the outside in with him on his shoes and on his hands and in the noise he makes. He said, "Grandma Miriam." I said, "There you are." He said, "I found a bug." I said, "What kind of bug?" He held out his closed fist and opened it with great ceremony. His palm was empty. He looked at it with genuine puzzlement. He said, "I had it." I said, "It probably escaped. Bugs do that." He thought about this. He said, "Maybe it went back to its family." I said, "That's very likely." He nodded, satisfied by the explanation, and ran back out to the garden. I watched him go. I thought, that child has my father's ears and Charles's persistence and two parents who made a serious mistake and are going to spend a long time making it right, and he will not remember any of this. He will remember Sunday dinners and the lemon tree and his grandmother's kitchen. He will remember being held. I am going to give him a great deal to remember. David appeared in the kitchen doorway. He looked at me and Renata standing at the counter. He looked at the rice. He said, "Can I do anything?" I said, "You can set the table." He went to set the table, and Renata and I kept working, and Michael and Carla's voices came in from the living room, and Alu's feet on the garden path were audible through the kitchen window, and the lemon tree was visible in the late afternoon light, still bare, still patient, waiting for spring the way lemon trees wait for spring, which is without apparent urgency and with complete confidence that the season will arrive. There are 3 things I want to say before I finish. The first is about the word confused. I began this story with that word because it is the word I have spent the last several months thinking about. Not because I was ever confused, but because I understand, now, the specific mechanism by which that word gets attached to a person who does not deserve it. It is attached to people who are old, and therefore assumed to be declining. It is attached to people who are quiet, and therefore assumed to be passive. It is attached to people who have spent their lives in service roles, interpreters, nurses, teachers, bookkeepers, the women who held things together in rooms where the important decisions were being made, and who are therefore assumed to be without resources of their own. The people who filed that petition believed I was confused because they needed me to be confused. Because a woman who was not confused was a problem their plan had not accounted for. I was never confused. I knew exactly what was happening, exactly what the errors were, exactly what to do with them, and exactly how long to wait. I am 67 years old. I have 30 years of professional precision in my hands, and in my ears, and in the green notebook in my kitchen drawer. I speak 3 languages fluently, and a 4th well enough to be trusted with the legal proceedings of people whose lives depend on accurate translation. If you are going to file a document saying I am confused, you had better have done your homework. Bertram Foss had not done his homework. The second thing I want to say is about patience. People use that word as though it is passive, as though waiting is the same as not acting. My father used it differently. He used it the way a builder uses it, as the specific, active discipline of not doing a thing before the time is right. Patience, in my father's understanding, was not the absence of action. It was the restraint of action in service of a better action later. I was patient for 3 months. I did not challenge the notice deficiency. I did not correct the name error in the Watts declaration. I did not reveal what I had memorized from the email on David's screen. I let Foss file his late supplemental declaration. I let Renata send her January 6th update to Paul Cleary. I waited until they had climbed as high as they were going to climb. And then I let Patricia Sue take the ladder away. That is not passivity. That is the most demanding form of action I know, because it requires you to hold your best evidence while someone says terrible things about you, and you are required to sit still and let them say it. I know how to do that. I learned it in 30 years of courtrooms where my job was to serve the language and not the outcome, to be accurate rather than effective, to render truthfully and trust the truth to do its work. The truth did its work. The third thing I want to say is about my father. Kwame Osai was a schoolteacher in Accra for 38 years. He taught mathematics and what he called precision thinking, which was his term for the practice of understanding a problem so completely that the solution was the only thing left. He was a meticulous man and a warm man and a man who believed, with the conviction of someone who had seen many things and tested his beliefs against them, that the truth was never in a hurry because the truth did not need to be. He died in 2011. He never saw me retire. He never met Alu. He never knew that his daughter would one day sit in a courtroom she had walked through for 30 years and watch a petition dissolve against the procedural errors she had been identifying since the second reading. But he is in every page of the green notebook. Every entry is in his handwriting, in a way. Every patient note taken in a situation that demanded patience, every number counted and dated and saved for later. Every decision to write instead of shout, to wait instead of chase, to let the truth arrive at its own pace because the truth is boring, and it is patient and liars are the ones in a hurry. I keep the green notebook in the kitchen drawer. Some evenings when the house is quiet and the lemon tree is visible through the window and Alu's drawings from last Sunday are still on the refrigerator, I take the notebook out and turn to the first page, where I wrote, in the hours after the petition arrived. 3 errors, do not use yet. I read those 4 words, and I feel, every time, the same thing I felt writing them. Not rage, not triumph. Readiness. That is what 30 years gave me, not certainty about the outcome, certainty about my own capacity to navigate whatever the outcome turned out to be. I was not confused. I was ready. And when they came for my house and my name and the right to speak for myself, I let them come, and I watched them build, and I waited until the structure was exactly as tall as it was going to get. And then I let the truth do what the truth has always done, which is to arrive, eventually, undeniable and complete, and outlast everything built against it. One more thing, and then I will let you go. It is spring now, 4 months since the hearing. The lemon tree has fruited. Not many 5 lemons, small and serious, the kind of fruit a tree produces when it has decided to prove something rather than to give generously. I picked them on a Saturday morning with Alu beside me, who had come to help, and had mostly carried the ones I handed him with great ceremony, and then put them in the bowl in the kitchen with the gravity of a small person who understands that some tasks require seriousness. He asked why the tree had lemons now. I said, because it was waiting for the right time. He considered that. He said, trees can wait. I said, everything worth having can wait. He looked at the lemons in the bowl. He said, can we make something? I said, we can make lemonade. He said, will it be sour? I said, very. He said, good. We made lemonade. It was very sour. Alu took 1 sip and made the face that children make when something is more extreme than they expected, and then took another sip immediately because the extremity was also somehow right. He said, it tastes like something. I said, what does it taste like? He thought about it seriously. He said, it tastes like it waited. I looked at him. I thought about patience and precision and 30 years of legal language and a green notebook, and the specific, quiet satisfaction of a plan that required no violence, no confrontation, no raised voice, no more drama than a woman sitting in a courtroom that knew her name and letting the truth arrive on its own schedule. I thought about my father. I said, yes, that is exactly what it tastes like. We drank the lemonade in the garden, Alu and I, in the spring light, beside the lemon tree that had finally decided to give us something. It was very sour. It was exactly right. Thank you for staying with this story all the way to the end. It is a long one, and I know it asks something of you. If the kind of justice that requires patience rather than noise, documentation rather than drama, and the very specific satisfaction of watching a poorly built case fall under the weight of its own errors is the kind of story you come here for, I would be honored to have you subscribe to American Dad Revenge. We tell stories about ordinary people who turned out to be exactly enough. We would be glad to have you with us whenever you are ready. Take good care of yourselves. There is something I did not tell you about the month between the hearing and the Discovery production, and I want to tell you now because it is part of the story that did not make it into the legal record, and that matters more, in some ways, than anything that did. 3 days after the hearing, I received a call from a woman named Cynthia Addo. She is 64 years old, a retired teacher from the district where I had gone to school, and she had seen something in the local legal notices, the published record of the petition, which is a requirement in California, and which I had not thought about in the weeks I was focused on the errors in the filing itself. She said, "Miriam, I saw the notice." I said, "Yes." She said, "Is it true?" I said, "The petition has been dismissed." She was quiet for a moment, then she said, "Are you all right?" I said, "I am all right." She said, "Because I want you to know I have seen this happen. To my aunt, 12 years ago. Her son filed something similar, and she was gone from her house within 6 months, and she never came back." I said, "I know it happens." She said, "She didn't fight it. She didn't know she could." I sat with that for a moment. I said, "Cynthia, can I ask you something?" She said, "Yes." I said, "Your aunt, how old was she?" She said, 71. I said, "Was she?" I stopped. I thought about how to ask the question accurately. I said, "Was she capable of fighting it?" Cynthia was quiet for a long moment. Then she said, "She was sharp as a tack. She had taught school for 32 years. She just didn't know she didn't have the language for it. She didn't know what a conservatorship was or what her rights were or what the errors in the filing might mean. She just knew that her son was saying she needed help and that the court had agreed and that there was a man coming to manage her accounts." I thought about that. I thought about the 30 years I had spent in courtrooms giving people language when the system was being applied to them in words they did not have. I thought about every defendant who had sat in that dock without understanding what was happening and what it cost them. I thought about the specific and particular vulnerability of a person who is competent and capable and simply does not know the machinery being used against them. I said, "Cynthia, I want to do something." She said, "What?" I said, "I want to put together a document, a plain language guide to guardianship and conservatorship proceedings in California, what the petition has to contain, what the notice requirements are, what errors to look for, what a proposed conservatee has the right to demand." She was quiet. She said, "For people who don't have 30 years in the courthouse." I said, "Yes." She said, "I can help you. I taught reading comprehension for 26 years. I know how to write for people who are frightened and need clarity." I said, "I was hoping you would say that." We worked on the document for 6 weeks. Cynthia and I sat at my kitchen table on Tuesday evenings, and I provided the legal content, and she stripped the legal language out of it and replaced it with something a person could read and act on without a law degree. We had it reviewed by Patricia, who made 2 corrections and said the rest was accurate and useful, and asked if she could give copies to clients who needed it. I said she could. Cynthia said, "Your aunt would have wanted this." I said, "I know, that's why we're doing it." We printed 40 copies and distributed them through the senior center, the library, and 3 community organizations that worked with elderly residents. I do not know how many people have read it. I do not know if it has helped anyone. I know that Cynthia's aunt moved into a facility she did not choose and lived there until she died and never went back to the house she had been in for 30 years. I know that she was not confused, not diminished, not in need of management. I know that the machinery of a poorly understood legal process, wielded by someone who loved her in the complicated, insufficient way that some children love their parents, took from her something she had not given and could not reclaim. I know that I was lucky. I had 30 years of institutional knowledge. I had Patricia Sue and the green notebook and my father's voice in my head and the specific, trained patience of a woman who has spent her professional life making sure people understood what was happening to them. Most people do not have those things. The document is 12 pages. It is written in the language Cynthia said she would use, plain, clear, unhurried. It tells you what a petition must contain. It tells you what the notice requirements are. It tells you how to identify a name error or a date error or a claim that has already been resolved. It tells you that you have the right to an independent evaluation. It tells you the name of the statute that requires it, and the section number, and exactly what to say if a court clerk tells you otherwise. It is, in its small way, the most important document I have ever been involved in producing. Because the truth about a proceeding like the one filed against me is not that it is rare. It is that it is common, and it succeeds most often against the people who know least about how to fight it. The errors in Foss's petition were not unusual errors. They were the ordinary errors of an attorney who does not specialize in contested matters and who expected no contest. Most petitions like his succeed, not because they are well-made, but because the person they target does not know how to see the errors. I knew how. I want other people to know how. That is what Cynthia and I built in my kitchen on Tuesday evenings, and it is the thing I am most proud of from the months that followed the hearing. Not the dismissal, not the discovery production, not the look on David's face when he read the emails. 12 pages in the library, plain language, clear rights, the machinery explained in words a frightened person can read. That is the work. That is what 30 years was for. I want to tell you also about Patricia Sue, because I have not told you enough about her, and she deserves more than the procedural role I have given her in this story so far. Patricia grew up in this county, the daughter of a woman who cleaned offices and a man who drove a bus for 30 years. She went to law school on a scholarship that required her to maintain a grade point average that she has described to me as genuinely terrifying to attempt. She built her probate litigation practice from a one-room office above a dry cleaner, in the same building she has been in for 19 years, because the rent is affordable, and she does not see any reason to pretend she is something other than what she is, which is a very good lawyer who has chosen to practice among the people who need her rather than among the people who can most easily pay her. She has represented more guardianship respondents pro bono or on reduced fees than any other probate litigator in the county, which I know because I asked her, and she told me after some reluctance, the way people tell you good things they have done when they would rather not be caught doing them. She told me once about a case she had lost, early in her career. A woman of 73, her first guardianship respondent. The petition had been filed by the woman's 2 daughters, who had hired a competent attorney who had made no procedural errors and had presented a compelling case built partly on documentation and partly on the particular performance of concern that people who want to take things from the elderly have learned to deploy in courtrooms. Patricia had done everything correctly. She had challenged every piece of evidence. She had argued the capacity question with precision and passion. She had presented her client with dignity and clarity. She had lost. The woman's estate had gone into guardianship, and she had died 2 years later in a facility her daughters had chosen, and she had never been back to her apartment with the view of the park that she had mentioned to Patricia in every meeting they had. Patricia told me this on the evening after my hearing, over the bad coffee in her conference room, with the kind of honesty that people offer when they are no longer performing professionalism and are simply talking to each other as themselves. She said, I still think about her, the park view. She mentioned it every time. She said the pigeons came at the same time every morning and she knew them. I said, what was her name? She said, Iris Brennan. I said, what happened to her daughters? She said, they sold the apartment 2 years after she died, bought a beach house. She said it without inflection. The kind of statement that has been made so many times in private that it has lost the energy of outrage and settled into something heavier and more permanent. I said, is that why you do this work? She said, I do this work because I'm good at it and because someone has to. I said, those are 2 different answers. She looked at me. She said, yes, they are. She poured more bad coffee. She said, your case is the cleanest I've ever had. 3 procedural errors, an independent evaluation that destroyed the clinical basis for the petition, and a discovery production that established the actual motivation. If I had designed a training case for how to defend against an abusive guardianship petition, I would not have been able to construct it this cleanly. I said, "Is that because I knew what to look for?" She said, "Partly, and partly because Foss was genuinely unprepared. He made errors that a more experienced attorney would not have made." I said, "Do you think David knew how unprepared Foss was?" She thought about that. She said, "I think David knew very little about what Renata was arranging. I think he was presented with a plan that had been packaged as concern, and he accepted the package without opening it." I said, "That's how I read it too." She said, "It doesn't exonerate him." I said, "No, but it explains him." She looked at her coffee. She said, "Do you think the bar complaint will matter to Foss?" I said, "I think the bar complaint will be investigated, and it will be found to have merit, and Foss will receive some form of sanction, and it will go into his professional record, and it will be there if this happens again." She said, "That's a minimal outcome for what he enabled." I said, "Yes, but it's a real one. The real ones matter." She said, "Your father's philosophy." I said, "My father's philosophy." She said, "Boring and patient." I said, "Exactly." She looked at me for a moment. She said, "What are you going to do with the next chapter? You're retired. You've won your case. You've produced the document with Cynthia. What's the next chapter?" I thought about that. I said, "I'm going to learn Portuguese. Properly. Not just legal Portuguese, the whole language. I spoke it enough to be useful in court. I want to speak it well." She raised an eyebrow. I said, "I'm also going to plant more in the garden. The lemon tree has demonstrated that it can fruit if it chooses to. I want to give it encouragement." Patricia looked at me for a moment with the expression she gets when she is not sure whether I am being completely serious. I said, "I'm also going to consult, informally. If people need help reading a petition, understanding what it says, identifying the errors. Not as an attorney, as someone who has read a great many of them." She said, "That's not nothing." I said, "It's not nothing." She said, "Will you charge?" I said, "Not money." She said, "What then?" I thought about it. I said, "Dinner. If someone I help decides they want to make dinner, I'll eat it." She laughed. Actually laughed with her whole face, the way people laugh when something is exactly the right combination of serious and absurd. She said, "That's the best payment structure I've ever heard." I said, "I learned it from a woman who taught me that the best things you can give are the things you already have." She said, "Your mother." I said, "My father." She raised her coffee cup. I raised mine. We drank bad coffee in her conference room in the early evening and talked about Iris Brennan and the view of the park and the pigeons that came at the same time every morning, and about what it means to lose a case that mattered and to keep practicing anyway, and about the 12-page document in the library and whether it would help anyone who needed it. I believe it will. I cannot prove it. I can only make it and put it where people can find it and trust that the truth of it will do what truth does, which is to sit quietly in plain language until someone who needs it comes looking. The truth is boring, and it is patient. It does not need me to be urgent on its behalf. It only needs me to write it down clearly and put it where it can be found. That I can do. That I have always been able to do. I want to tell you one more thing before I finish, and it is about the night of November 3rd, which was 3 weeks after I retired and 4 days before the petition arrived, and which I have not mentioned yet because it belongs at the end rather than the beginning. I was in the garden. It was evening, early dark, the particular quality of a November evening when the year is late and the light goes quickly, and you find yourself outside later than you meant to be. I had been deadheading the last of the autumn flowers, the kind of small maintenance work that is entirely unnecessary and entirely satisfying, the kind you do because you want to be in the garden and need a reason to stay. I was thinking about Charles. I think about Charles in the garden often, because the garden was his project in the years before he died, the thing he turned to when the work of being sick became the only work available, and he needed something else to do with his hands. He planted the lemon tree. He built the raised beds. He put in the path of flat stones that runs from the back door to the tree, which is uneven in 2 places and which I have never repaired because the unevenness is his. I was standing at the base of the lemon tree in the November dark, thinking about Charles and the stones and the 34 years of this garden, when I felt something that I want to describe as accurately as I can. I felt the weight of the house behind me, not literally, but the specific felt sense of a thing you belong to and that belongs to you, the relationship between a person and a place that is built over decades of ordinary days. The kitchen where Charles folded his newspaper, the drawer where the green notebook lives, the third shelf with the hand lotion. I felt the weight of all of that, and I understood, in the November dark, that whatever was coming, and I did not know yet that the petition was 4 days away, but I think some part of me understood that something was coming. I was not going to leave this house. Not for a developer's Q2 target. Not for a facilitation fee. Not for a petition drafted by a man outside his area of expertise who had made 3 errors in the first reading. I was not going to leave this house. I went inside, I made tea, I sat at the kitchen table, and I wrote in the green notebook, before there was anything specific to write about. Whatever comes, I am ready. 4 days later, Foss's petition arrived. I sat at the kitchen table with it and the pencil, and read it twice, and wrote 3 errors, do not use yet. And I was ready. The lemon tree fruits now every spring. Not in abundance, it is not that kind of tree, but it fruits. 5 or 6 lemons, serious and tart, the fruit of a tree that has decided to commit. I make lemonade when Alu comes. He always takes 1 sip and makes the face, and then immediately takes another, because the sourness is also somehow exactly right. He asked me last Sunday where lemons come from. I said, from the tree. He said, no, but before that. I said, from a seed. He said, and before that. I said, someone put the seed in the ground and waited. He thought about this seriously, the way he thinks about things that require actual consideration. He said, how long did they wait? I said, a long time. He said, was it worth it? I looked at the tree. I looked at him. I looked at the lemonade in his cup, very sour, very tart, the exact product of patience and good ground, and the particular faith that what you plant will eventually become what you were waiting for. I said, yes, it was worth it. He nodded and took another sip and handed me his cup for more. I poured it. We sat in the garden together, the 2 of us, in the spring light. And the lemon tree was very still, the way things are still when they are done with the hard part and have arrived, finally, at the season they were built for. That is the whole story. Thank you for being here for all of it. I know it was long. I know it asked something of you. A story about patience is, by necessity, a long one because patience does not compress. If you would like to hear more stories like this one, about ordinary people who knew exactly who they were when someone told them otherwise, we would be grateful to have you subscribe to American Dad Revenge. The button is there whenever you are ready. No pressure, no urgency. Only the invitation and the confidence that you will come when it is right. Take care of yourselves. I have been thinking, since I finished telling you the main shape of this story, about a conversation I had in 2009. It was a Tuesday in February. I was interpreting in Department 7, a criminal matter, assault charge, and the defendant was a man of about 50 who had been in the country for 11 years and had never learned more than conversational English because he had worked every hour of those 11 years and had not had the time or the money for the classes that would have given him the language. He was a carpenter. His hands told you that before he said a word. The kind of hands built from 30 years of work, large and precise and calloused in the specific places that tools make calluses. The charge against him was assault. He had pushed a man at a job site. The man had fallen and broken his wrist. The prosecutor characterized the push as an attack. The defendant's own attorney, a young public defender who was doing her best with too many cases and not enough time, had difficulty communicating with him because the informal interpretation being provided before I was assigned had been, at best, approximate. I sat beside him, and I interpreted. I gave him every word in the language he had, and I gave the court every word of his in the language it required. And I did this for 2 days, which was how long the trial lasted. He was acquitted. Not because of me, I am a conduit, not an advocate, and the distinction matters, and I have always observed it. He was acquitted because the testimony, once the jury could actually hear it accurately, told a different story than the prosecution had constructed. He had not attacked. He had stepped back from a man who was threatening him, and the man had stumbled. The stumble was real. The fall was real. The broken wrist was real. The attack was not. After the verdict, in the corridor outside the courtroom, his attorney thanked me. She said, "Without you, he would have been convicted on the approximate version." I said, "He deserved the precise version." She said, "Most people who come through here don't get it." I said, "I know." She said, how do you sit in there every day with that, knowing how much depends on your accuracy and how much is lost when accuracy fails?" I thought about that. I said, "I do it the way my father taught me to do hard things, which is not to hold the weight of all of it at once, but to do the precise thing in front of me to the best of my ability, and to trust that precision accumulates." She looked at me. She said, "That's a lot of faith." I said, "It's not faith in a system. The system fails regularly and obviously and in ways that damage real people. It's faith in the specific work, this word for that word, this sentence for that sentence, as accurately as I am capable of making it." She said, "And you think that's enough?" I said, "I think it's the thing I can actually do, so I do it as well as I can." She nodded. She had another case in 3 minutes, and she was already moving toward the next courtroom. I thought about that conversation a great deal in the months of the petition. I thought about it when I read the errors in the filing and wrote "do not use yet." I thought about it when I sat in David's living room and drank his tea and memorized 3 paragraphs from an email on his screen. I thought about it when I sat in the chair across from Dr. Asamo and named 41 animals in 60 seconds and included one in Haitian Creole because the word was more beautiful. The precise thing in front of me, to the best of my ability. Trust that precision accumulates. It accumulates. I know that because I am standing in my kitchen 30 years after I sat beside a carpenter in Department 7 and gave him back his own words in a language the court could hear. I am standing in my kitchen with my name on the deed, and the green notebook in the drawer, and the lemon tree in the garden, and my granddaughter Amara, Carla and Michael's daughter, born 6 months ago with a remarkable head of hair and the calm, assessing expression of someone who has already decided to take her time before committing to a position on anything. She does not know about the petition. She does not know about the green notebook or the 3 errors or the hearing or the emails. She will not know for a long time, and by the time she is old enough to hear the story, it will have settled into family history the way things settle, flattened a little, simplified, the procedural details fallen away, and what remains being the shape of the thing. What I want the shape to be, for her, when she is old enough to hear it, is this. Your grandmother knew what she was. She knew what she had built and what she had learned and what her years had made her capable of. And when someone told her she was less than that, she did not shout and she did not chase, and she did not perform her own competence for an audience. She simply opened the filing and read it twice. And she found the errors. And she waited. That is the story I want her to know. Not the victory, though the victory is real. The method. The patience and the precision and the absolute refusal to be confused about who she was, even when someone with a legal document was insisting otherwise. I was not confused. I am not confused. My name is Miriam Abina Osai. I am 67 years old. I spent 30 years making sure people understood what was happening to them in rooms where the language of the proceeding was not the language of their lives. And when someone tried to apply a proceeding to me in the language of my own life, without understanding that I had spent 30 years learning to read every word of it, I applied everything I had learned. Quietly, precisely, and I waited for the truth to arrive on its own schedule. It always does. It always will. That is the last thing I will tell you, and it is the only thing, really, that I have ever needed to know. Thank you for listening all the way to the very end. There is a woman I want to tell you about whose name I do not have permission to share, and so I will call her only what she called herself when she found me 3 months after my hearing, which is lucky. She had seen Cynthia's notice about the document we had placed in the library. She called on a Thursday morning, an older woman's voice, careful and deliberate, the voice of someone who chooses words because she has learned that imprecise words are expensive. She said, "I read the document, the one about the petition." I said, "I'm glad." She said, "My daughter filed one against me last year." I said, "What happened?" She said, "I didn't fight it. I didn't know how. I didn't know about the 30-day requirement. I didn't know I had the right to my own evaluation. I didn't know any of it. I trusted that the process was correct, because it was the court, because courts are correct." I said, "They're not always correct. The process requires attention." She said, "I know that now." She paused. She said, "I lost my house. My daughter arranged a sale and I'm in an apartment now. It's a nice apartment, but it's not the house I raised my children in." I sat with that for a moment. I said, "I'm sorry." She said, "I'm calling because I want you to know the document is good. It says what it should say. If I had had that document 18 months ago, I might have known what to look for. I might have found the errors." I said, "Were there errors in your petition?" She was quiet for a moment. She said, "I have the petition. I got a copy from the court 2 months ago when I started to understand what had happened. There are 2 things in it that I now think might be problems, but I didn't know then. I just didn't know." I said, "Would you like to sit down and go through it together?" She said, "That's why I called." She came the following Tuesday. She sat at my kitchen table, the same table where Cynthia and I had written the document, and she spread out the petition and the notice and the evaluation and the court order, and I put on my reading glasses and I read. She was right, there were 2 things. Neither of them was actionable at this stage, 2 years out, with the sale completed and the court order standing. Patricia reviewed them and confirmed that the window for challenge had closed. Not every story has a courtroom resolution. Not every error is found in time. But I sat with her for 2 hours. I explained what I found and why it mattered, and what it would have meant if she had known to raise it. I gave her the language for what had happened to her, the precise legal language, because a person deserves to understand the machinery that was applied to them even when the machinery cannot be reversed. She left with a copy of the document and the name of an attorney who could advise her on any potential civil remedies that might still be available. She also left with a piece of lemon cake I had made that morning because I had learned from my mother that some conversations are better finished with something sweet. At the door, she said, "You said the apartment is nice." I said, you said the apartment is nice." She smiled, a small, careful smile. She said, "It has a window that faces east. I see the sunrise every morning." I said, "That's something." She said, "My daughter says I'm happier there." I said, "What do you think?" She was quiet. She said, "I think I'm different there. Whether that's happier or something else, I'm still working out." I said, "That's an honest answer." She said, "I learned it from a document in a library." She thanked me and left, and I stood in the doorway and watched her walk to her car, a small woman with good posture and the particular bearing of someone who has been through something real and come out the other side not unscathed but clear-eyed. I went back inside. I sat at the kitchen table. I opened the green notebook to a fresh page. I wrote, "She came. We read the petition together. Too late for the court, not too late for the understanding." I wrote, "That is also something." I closed the notebook. I thought about my father and his schoolroom in Accra and the students who sat in front of him learning precision thinking, and the ones who went on to use it, and the ones who forgot it, and how you cannot know, when you teach something, which of those categories the student will fall into. You can only teach it well. You can only make the document and put it in the library and sit at the kitchen table when someone calls. You can only be there. The truth is boring, and it is patient, and it does not require me to carry it to every person who needs it. It only requires me to put it somewhere they can find it, and to answer the phone when they call, and to have lemon cake ready, because some conversations are better finished with something sweet. That is the work. That is all of it. And it turns out to be exactly enough.